Welcome to our YouTube video series on employment law, focusing on employee terminations. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing the importance of not putting too much faith and believing everything that appears in your payroll statements. And I make this claim simply because payroll software has advanced, but it's advanced more on the technical side, and in so doing has, in many respects, driven itself away from the core aspect, that being the legal requirements that must be met with respect to pay statements, payroll calculations, and the like. And it doesn't matter if you're talking about ADP's pay statements, Ceridian's pay statements, SAP's pay statements, UltiPro's pay statements. All these pay statements and payroll systems, unless they've been operated correctly, and this in part is driven by the company itself, is not going to necessarily produce the accurate pay statements and payroll for you, the employee. And as such, there is a strong likelihood, at least from my own analysis, that you could find yourself getting underpaid, because payroll systems and employment standards legislation is far more complex, especially because of the multi-jurisdictional nature of employment standards legislation, where there's significant differences between countries, states, provinces, that you have a software that is designed originally in one location, but does not necessarily work perfectly in other locations because the laws are different. So what happens is oftentimes you have software programs being developed that are developed in oftentimes the United States, and in states where there is minimal requirements with respect to additional costing for the employees, additional components. And because of that, the payroll software can be rather simplistic. The problem arises when you go to not so simplistic employment arrangements. And these arrangements oftentimes happen in certain industries and certain countries where there is just more focus and more specificity in the legislation, number one, and the number of benefits, payments, allowances, bonuses, and the like that are paid to one's employees. So what happens is that you could have payroll software that works functionally well with restaurant workers in the southern United States, where it's rather straightforward. You get regular time and overtime, and the payroll laws of that state are pretty straightforward. Even if there's some complexities, it's worked into the software because they're pretty well known. But as you move from state to state, and then more so when you move from United States up to Canada, you run into different issues and different problems arise because there's differences within the jurisdictions that make certain things become more prominent, make calculations different, computations different, and at the same time, the laws keep on changing such that modifications are required. And the payroll software companies, meanwhile, although they do advance their software tends to be advanced from their home jurisdiction, their home city. And if you're a couple steps removed, meaning that you're in another country, and then even in that other country, you're in another province than the main province from which they work, there's a tendency to have the software not operating according to the laws of your own particular jurisdiction. And this causes significant issues, because now you run into problems, and what happens is payroll is working feverishly, underpaid typically, as opposed to the accountants and the lawyers in the company. And they don't really necessarily understand the nuances of the law, the changes in the law, the differences between one law and the other law. And they simply operate the payroll software as it has been provided to them. They don't look to see where they might be paying employees more. That is not their job. They don't look to go beyond what they've learned. And oftentimes what they've learned is not specific to their own jurisdiction. Oftentimes they've learned base laws which are either coming out of the States or in Canada, oftentimes coming out of Ontario. And there are significant differences between the various provinces, especially all provinces outside of Ontario. But if you don't pick that up and there's nothing being produced properly to show you what the discrepancies are, you're not going to do much. You're not going to start changing stuff. Payroll people are not software people. Software people are not payroll people. And software people are definitely not lawyers. And if you look at even the contracts that these payroll companies have with the software side, is they make the companies responsible for the inputs. It's up to the companies and their payroll staff to ensure that the inputs are correct and the computations are correct. Once they get the numbers put in, the computations set out, then they will be able to provide the outputs. But if you don't put in the correct computations, it means the arithmetic formulas that are consistent with the province. And if you don't do that, you don't know how to do that, well, you're in trouble. And all too often, when you contact the payroll software companies, they don't know better. It's not their job to come up with these computation formulas. It's their job to simply to take them in and to put them into their computer system, if anything, and hopefully get the outputs. And if somewhere along the line there's a mistake, the mistake will fall upon the company and not on the payroll software company because of their contractual provisions to protect them from liability in that sense. But that all being said, who's the net loser in this entire process if they don't address it correctly? The net loser is you, the employee. And especially where you get terminated, you're going to find yourself looking at a pay statement that looks professional. And it looks that way. It seems to be calculated correctly. The numbers from the most basic level might seem to work correctly. But I've seen far too many times that those computations are incorrect. And unless you know what the computations are behind and the discrepancies between the jurisdictions, you are not necessarily going to see where the problems lie. And it is because of those problems, because of those computational errors that are hidden in some respects, because they're using the wrong arithmetic formula. The formulas might appear to be correct when they aren't correct. So the numbers seem to add up. The multiplication seems to be correct. But if you're using the wrong formula, you can get the wrong numbers. And in most cases, you're getting underpaid. So what do you need to do in those circumstances? What you need to do is you need to talk to legal counsel who knows what I'm talking about, who knows and understands how to discern what the correct computational formulas are. And this is in part legal, and it's part arithmetic. It's mathematics and the law combined, but doing it correctly. And too many companies, and even the payroll software companies, fail to understand this and fail to do this properly because that's not what they're there for. They're so large, they have one center, and that center does not come in and say, we know the different employment standards law and all the computational formulas for 50, 60, 70, 80, 90 jurisdictions. They don't know that. That's not necessarily their job. It should be, don't get me wrong. When you go to ADP, Ceridian, UltiPro, SAP, and all these other payroll companies, they're so big, so vast, but they don't necessarily have that working framework in front of them. And part of it's because they don't want to be on the legal side. They're not law firms. They're payroll computational software companies. That's what they're doing. They work off of scale and size, and they don't get into the specifics. And meanwhile, even though human resources, payroll is such a large proportion of costs of companies, especially these very massive companies, they don't put in the time. They focus on other stuff. And nobody works through the numbers. And if they even did work through the numbers, after years of doing it correctly, they're in legal jeopardy should they change the stuff because somebody might well pick it up, identify the error that they identified, and now come back and sue them. Major problem for companies and changing their payroll systems. And since rarely do people ever challenge them on this stuff, they just keep on doing what they're doing. They continue to underpay their employees, keep on not addressing properly the changes and developments in employment standards legislation, the changes to payroll calculations, and they proceed to continue to underpay people. And that is what continues to go on. And as I've said in other videos, it's difficult to deal with this stuff when you're working for the company, because when you're working for a company, you can't really be in a position to challenge them. Here, though, lies where you have to do almost. You have to collect your information, hold it together, talk to legal counsel, have a plan, so when you quit or you're terminated from your job, you have the materials necessary to ask for all that underpaid money. It can be minimal, it can be significant. If it's minimal, it potentially gives you leverage with respect to your termination and severance package. Or it's more significant, it also gives you leverage with respect to your termination and severance package, but it can represent a significant amount of money that you are owed, and it has to be paid on top of everything else. In addition to the fact that it gives your legal counsel a lot of strength and clout with which to proceed with dealing with your former employer. Because people fail to realize that when you're terminated, typically lawyers look at two aspects. They look at termination pay and severance pay. Termination pay being dictated by statute, severance pay being based on common law. The problem is termination pay is established, severance pay, there's some discretion in it. And typically what is seen is that the companies hold a lot of leverage. Problem is, for them, you got to reassert leverage. And how do you reassert leverage? Is you get into another statutory aspect, which is clear cut if you can establish computational formulas and the underpayments during the course of one's employment, such that now you have additional leverage. And a smart lawyer is able to work that to your advantage to get you the severance pay that you're entitled to, get you the termination pay that you were always entitled to, and also to get your outstanding underpayments from the course of your employment, which is also statutorily based. And that is what you're aiming for. So in the end, do not put too much trust and faith in the pay statements that you receive, whether they're internally generated They're generated from a payroll company. You cannot give all your faith to those pay statements and to the computations that are arising from them. You have to understand that the major problem with pay statements is a question as to whether or not they were using the right computational formulas, the right math to do stuff. Because if you're not using the right math, you can look like you're getting the right answer, but if you're calculating based on the wrong set of numbers, the outcome will be wrong because it's the wrong number to start out with. And you have to understand that. To understand the significance of pay statements, the problems with pay statements, and why you don't necessarily trust them outright. You still have to question them. You really should talk to legal counsel and ascertain whether the pay statements are in fact accurate. And if they simply are a matter of they look professional, they look like they contain a lot of information, the numbers seem to calculate right, that is not enough. You cannot stop there. You have to see what the arithmetic is. You got to make sure the formulas are correct, the formulas are applied correctly, the numbers are inputted correctly into those formulas, and the process is right. Because if you do that, you can determine whether or not you've been paid correctly over the course of your employment. And if you haven't been paid correctly over the course of your employment, you can address it when you get terminated and not only get those underpayments back, but have the leverage to get your proper severance pay that you should be owed to yourself. And that's what you should be doing when it comes to reviewing pay statements. You can't simply look at them for 5 seconds. They take time, they take understanding. And especially when you've worked a long time, it's important that you get all that you are properly and legally entitled to from your former company. Thank you.